Welcome to TFE Talks, Navigating Wealth, Business, and Legacy, the podcast from Thomas, Fisher, and Edwards. Each episode, our attorneys bring you expert insight on estate planning, business strategy, and legacy building, breaking down complex topics into clear, actionable advice. Whether you're solidifying a strategy we've discussed or preparing for what's next, this podcast is your resource for thoughtful, practical planning. You ready? Let's dive in.
Hello and welcome to another edition of TFE Talks. I'm your host, Jordan Goewey, joined today by David Thompson, another attorney here at Thomas, Fisher, and Edwards in Greenville, South Carolina. David, thanks for joining me once again.
Happy to be here and talk about some of the new changes to South Carolina law.
Yeah, and that is what our topic is today. There was a recent statute that was passed by the legislature here in South Carolina that really affects a lot of what we do in the estate planning context. And so, David, why don't you just start off by telling us what this new law is, what its primary purpose is, and when it became effective?
Yeah, so the new law, the title of the new law is Grantor Trust Reimbursement. So the primary, I think, or at least the initial starting place for the legislature here in South Carolina was taking a look at how Grantor trust taxation and reimbursement could work in this state. And I think that's kind of the headline change. However, as you noted, there are a number of other kind of maybe less considered more minor changes. However, they can have a large effect depending on what kind of planning you're using and impact the types of trust that we use daily. The law is effective as of May 8th. However, many of the provisions can apply to pre-existing trusts depending on the terms of those trusts. So you have to take careful evaluation of what your terms say and evaluate whether you maybe this new law does apply.
Again, the headliner is that this deals with Grantor Trust reimbursement. And so can you kind of touch on what is a Grantor Trust? What exactly is Grantor Trust reimbursement, and why is that important in the trust planning context?
Yeah, so Grantor Trust, and we could spend a whole podcast or a series of podcasts talking about all the provisions and complexities related to Grantor Trust. But at a very baseline level, Grantor Trusts are trusts that are deemed taxable to the grantor. Now, generally, that's the creator of the trust. There are some exceptions to that, but generally, it's the creator of the trust. And why that matters is I could create a trust that maybe someone else is the beneficiary of, but I am individually paying the income tax in connection with the assets of that trust. Now, depending on what's in that trust, that could be very, very expensive over time for me. There are a variety of reasons that is good planning, which we're not really going to go into here today. But what this new law does, and so historically, South Carolina, if you create a trust and you retain some sort of benefit, it's deemed to be a self-settled trust to the extent of that interest. And the fact that it's self-settled means that the trust is, or whatever you've retained the rights to, whatever income or distributions that you've retained, is generally accessible by your creditors. And in addition, that has a state tax and other tax effect that is detrimental generally to traditional forms of uses of grantor trusts. Not to say that it could never be used, but as a general rule, is kind of antithetical to what we're trying to achieve a lot of times with a grantor trust. Now, the new law actually allows a trustee to distribute to the creator of the trust, grantor, in connection with income that is caused by the trust's inclusion in the taxpayer's gross income. So functionally, it allows some trustee to potentially make a distribution to cover some of the tax that's caused.
So it's really kind of a combination of creditor protection considerations and also just flexibility, because to your point, we do at times, and we don't have time to go fully into all the different planning ideas today, but we do at times set up trusts where we want that grantor to be able to pay those income taxes because it can really have major estate tax benefits and allow the assets in the trust to grow free from those income taxes for the benefit of the beneficiaries. But a downside is that at some point, the grantor may be overly burdened by that income tax payment obligation. And so this new ability that we now have in the state of South Carolina to have that obligation, but if it ever becomes too much of a burden, potentially have the trustee come back and reimburse the grantor for a portion or all of that while still maintaining the creditor protection we want is really a big deal and gives us a lot of flexibility.
Yeah. And to bottom line it, the key component is that the grantor can retain that potential right of discretionary distributions, and the trust is not self-settled as to the portion that could be distributed back to grantor.
That's right. And so interestingly enough, the law also built in another concept about self-settled trusts and how they work, because within the same statute, there's another provision that deals with powers of appointment being appointed to a grantor. And so can you touch on the importance of that and the flexibility that it provides?
Yeah. So at the highest level, the new statute also provides an ability for, let's say I create a trust for my spouse or a friend or a relative. It's theoretically possible that in that trust, I could give some individual, maybe an unrelated person, or maybe even a beneficiary potentially, the ability at some future time to potentially appoint assets back to me through the use of a power of appointment. And functionally, what the statute says is that by the exercise of that power of appointment, right, for purposes of the self-settled trust statute, it is deemed as if the person that exercises the power is the creator or the grantor. So what that means is there may be potential where we could create trusts and potentially at some future time, for lack of a better word, backdoor the grantor or creator back into the trust if advantageous at some future point. Now, there's a myriad of other, estate tax and gift tax concerns that you need to evaluate when you're planning for something like that. But it definitely increases the flexibility for a lot of these irrevocable trusts that we're creating.
Yeah, that's right. Again, I think flexibility is the name of the game. I typically sit down with my clients anytime we're doing irrevocable trust planning, and I have to have a very serious conversation about the fact that when you give these assets away to the irrevocable trust, you can never get them back. And so this new ability to maybe have a power of appointment back to the grantor, as you noted, there are myriad reasons that it's more complex than just doing that. A lot of considerations have to go into allowing for that, but it at least gives some potential ability that maybe you can get those assets back. And so that can really be a game changer as part of that irrevocable trust planning.
I think it really can open the door for maybe a younger client that is not as keen of potentially parting with the assets, given, they don't know exactly where life will take them over the next decades of their lives. But it can potentially be that extra bullet of flexibility that, says in their mind that, okay, maybe I'm okay to implement this tax strategy or this plan because I have more options, more arrows in my quiver, so to speak.
Yeah. And so that's really good information on kind of the primary purposes of this statute related to grantor trust reimbursement and potentially also having this ability for powers of appointment back to grantor and the flexibility that those provide. As part of this same statute, if we shift gears a little bit, the legislature also included some changes to the rule against perpetuities, which has been something that's been changed in a lot of states, and South Carolina is now kind of getting on board with this as well. So can you talk for a moment about what the rule against perpetuities is and the effect that it has on trusts, and then what is the recent change that South Carolina had related to the rule against perpetuities?
And we actually talked about this on a little bit on a previous podcast that was about dynasty trusts. And well, we released that. I think almost shortly thereafter, they made this change in our law. But functionally, what the rule against perpetuities is it is a rule that attempts to limit how long property can be tied up in a trust or other kind of restraint alienation without it vesting in an individual. Now, traditionally, under the common law rule, which South Carolina had a form of that, you would be thinking it would last, for all the lives in being at the time of the interest became irrevocable, plus 21 years. Generally, that's around 90 to 110 years. However, it's kind of a fact-specific question as to exactly how long the trust will last. The modifications that they made in this statute actually extend the rule against perpetuities to 360 years. So we have a longer wait and see period that basically means that, we, for most intents and purposes, for most planning and for most clients, we've effectively done away with the rule against perpetuities as it's going to apply to the average estate planning client and trust that we create. Now, for very large trusts or, maybe specially designed trusts where there may be limits on how much money is spent or how the property is used, this opens a lot of additional planning options for clients that want to pursue those kinds of routes.
David, you mentioned that we did a previous podcast on dynasty planning. I encourage all of our listeners to go back and listen to that podcast if they haven't already. But also, even if you listen to that podcast, you can go back and listen to it again now. And anywhere in that podcast that we talked about 90 to 110 years or any sort of similar time frame being how long a dynasty trust could last, you can now replace those statements with 360 years, which makes all of the planning we talked about in that podcast even more valuable now because, again, kind of the general concept of a dynasty trust is it's staying in trust for multiple generations, staying outside of the estate tax system for multiple generations, being protected from creditors for multiple generations. And so now we can do that for 360 years. So everything that we talked about in that podcast is even more valuable now with this new act. With that in mind, what do clients need to do with this new change to the rule against perpetuities? If they have an existing trust or if they're considering setting up a trust, how does this affect estate planning?
I think they need to review their documents and see what their goals are, right? See what their wishes are. If they want to take advantage of these longer perpetuities periods and options for these trusts to last longer, they need to look at their documents and then consult with somebody to see if the existing language in their trust, is effective in the sense that it would fall under the new 360-year rule. For example, the technical changes of the statute may necessitate that certain language that was previously used needs to be modified in some form or fashion by an attorney just to make sure that you fall within the 360.
Yeah, and I certainly think having those prior documents reviewed, because even though the new law is theoretically retroactive, if the terms of the trust were contemplating a 90-year period and now the law's changed, then those terms may need to be updated in some way. And in some cases, they'll be able to be updated, such as in the revocable trust concept. In the irrevocable trust concept, there may be limitations to updates that can be made.
In an irrevocable trust concept, to bring it full circle, you're correct, Jordan, that you would have to seek, potentially consider like a reformation action, which the statute, the changes actually also contemplate, and discuss a little bit about that, where you could potentially petition a court for clarity on what the rule, how this new statute interplays with your existing irrevocable perpetuities provision that's in a trust.
Right. And so, David, as always, we like to give our clients and listeners practical advice. And so with this new passage of the new statute here in South Carolina and these important changes to the laws in the trust planning context, what practical advice do you have for our listeners today?
I think the practical takeaway is, I think South Carolina has always been in the top third of states for considering these type of trust arrangements. However, the changes that they've made make it an even more attractive state for a lot of the types of trust planning for estate and gift tax purposes and other planning, creditor planning, than it was, last year, right? So I think the takeaway is, where you may have had to go to a different state and have maybe a more complex trust arrangement to achieve certain things, that may now be possible here if you live in South Carolina in your home state, which I think is important for everyone to be aware of and consider.
No, that's a very important point, and something that with you and I, we both are licensed in Tennessee, in part because in the past we have wanted to go to Tennessee and use their laws for certain types of trusts. We still want to do that at some times because Tennessee is is still a very advanced trust jurisdiction. But a stated purpose of this new law was to keep trust business in South Carolina, and it's a huge step towards doing that because it certainly allows us to do a lot more of the planning in South Carolina than we were able to do before, which is certainly our preference for our clients that are based here.
Absolutely.
Well, David, thanks for joining me again today to update us on this new statute, and I look forward to having you on further episodes of the podcast so that we can continue to talk about these interesting subjects.
Thanks, Jordan.
Thanks for listening to TFE Talks. For more information, please visit our website at www.tfelawfirm.com. You can also follow us on LinkedIn, Facebook, and Instagram by clicking the links below in the show notes. If you have any questions about topics discussed in the episode, or you have recommendations for future topics, please email us at info@tfelawfirm.com. See you next time.